Welcome everyone for, I don't want to say the last panel of these big data hearings, I'll say the ultimate panel of these big data hearings. We have the former enforcer's perspective. Where do we go from here? What is right, wrong, or indeterminate about data policy? We've assembled a small but very distinguished panel here to have a wide-ranging discussion of issues we've been covering these past 2.5 days, both looking at what's been done and what's been learned, and also looking forward to data policy. So let me just introduce, first of all, my colleague Katie Ambrogi, who is, like me, from the FTC's Office of Policy Planning. And then our panelists, Bill Baer is a partner at Arnold & Porter. Previously, he served as Acting Attorney General at the Department of Justice, Assistant Attorney General for Antitrust Division at the DOJ, and Director of the Bureau of Competition at the FTC. Prior to that, he was Assistant General Counsel and Director of Congressional Relations and an Attorney Advisor to the Chairman of the FTC. Julie Brill is the Corporate Vice President and Deputy General Counsel for Global Privacy and Regulatory Affairs at Microsoft. Julie is a former commissioner of the FTC, where she served from 2010 to 2016, and was widely recognized for her work on internet privacy and data security issues related to advertising and financial fraud. In 2015, she was named one of the top 50 influencers on big data. Maureen K. Olhausen is a former FTC commissioner, serving in that role from 2012 to 2018, and as acting FTC chairman from 2017 until May of this year. Before that, she was a partner at Wilkinson Barker Knauer, where she focused on FTC issues including privacy, data protection, and cybersecurity. She previously served 11 additional years at the FTC, most recently as the director of the Office of Policy Planning, where she led the FTC's Internet Access Task Force. Before that, she worked at the U.S. Court of Appeals for the D.C. Circuit, serving as a law clerk for Judge David B. Santelli and as a staff attorney. She's authored a variety of articles on competition law, privacy, and technology matters. As we said in previous sessions, anybody just arriving, this is being photographed and recorded and transmitted as a webcast and archived. And that's our notice about public use of your images and anything you might say, and we'll collect question cards. But now I want to turn it over to our panelists, each of whom will have brief opening remarks before we get into a more free-ranging discussion. So let's start with Bill Baer.
Well, thank you. I was reminded to push. I am going to make very brief opening remarks because, in fact, the two former FTC officials to my left and my right have actually been in that unique position of enforcing Section 5 of the FTC Act, which does bring together these issues of antitrust enforcement and consumer protection enforcement. But I would say, and we'll talk about this more, I think, as things go on, I do think it is important analytically, and the Commission has done a good job of this, of separating what is an antitrust problem and what is a consumer protection problem where data privacy, security need to be addressed. The competitive market can create these sort of externalities where competition isn't taking into account certain costs to society and to consumers from a lack of competition or on privacy and data security. And those are areas where I think the Federal Trade Commission and, to a lesser extent, certain other regulatory agencies have a unique ability to influence how we think about it, how we regulate it to the extent the authority exists, and how the executive branch and the independent agencies interact with Congress to make sure that we are actually making sure that consumers aren't bearing unreasonable and inappropriate costs of competition in these markets.
Well, it's great to be here. Thank you to Bilal and to Dan and to Katie for inviting me to speak about this incredibly interesting issue. What I thought I would do to begin, just with my opening remarks, is to talk a little bit about one of the questions that I have noticed was discussed and interwoven in many of the conversations over the past couple of days, and that is our companies competing on privacy, and what does it mean to actually be competing on privacy. And in my last slightly over a year at Microsoft, as well as my year serving as the head of a major law firm's global privacy and cybersecurity practice, from my perspective and my vantage point, I can say that companies are vigorously competing on privacy, but it might be in ways that might not be quite as intuitive or obvious to some individuals. So I'd like to talk about that briefly. So first of all, from Microsoft's perspective, we are competing in many, many different types of markets. But if you want to break it down into two, just for the moment, we serve, obviously we have a very large cloud business where we are providing services in the cloud to many other businesses and individuals. And in that context, our ability to protect data and to provide tools to our customers so that they can be compliant with privacy laws around the globe is a very important differentiator, a very important competitive aspect of what we do. Similarly, we differentiate with respect to our use of data for end users, for consumers. So it's important to think about the actual business model that's involved and to think about what it is that entities are doing to differentiate themselves in terms of their data practices and their data policies. I'd like to drill into this a little bit more if I can, and let's see if my slides did get loaded. So how do I... Oh, the large green button. There we go. There's been a lot of conversation, I think, about GDPR also over the last couple of days. And I have learned an awful lot about GDPR in the last 3 or 4 years. And I think it's important to truly understand what GDPR does do and actually what it doesn't do. There is a meme that runs through Washington that GDPR requires consent for all sorts of data use, and it's very heavily focused on a consent-based regime. That's actually not true at all. Indeed, for having been written 7 years ago, it's a remarkably agile law. Is it perfect? No, by no means. No law is perfect. We could sit around and talk about any law, whether it's COPPA, FCRA, GLB, and we could talk about the need to update and modernize. But GDPR, for a law that is a baseline privacy law that governs all forms of data use for an entire continent and actually, indeed, for the entire globe in many respects, is remarkably agile. And I'll be getting to the competitive aspects of this in a moment, but I just wanted to lay some baseline understanding of the law. There are 3 essential aspects to it: transparency, empowerment, and accountability. GDPR does require very robust disclosures to be provided to end users and also to be provided on behalf of processors to customers. That is to the processors' controllers. So I won't get into too much lingo here, hoping that everybody sort of understands some of the basic lingo and terminology that GDPR uses. But transparency is a very important aspect. Empowerment is also a very important aspect of GDPR. It provides all forms of control, or many forms of control, to end users for how they can understand their data and access their data and do things with their data, like delete it, like correct it, things like that. There's also a large emphasis on accountability under GDPR, where companies need to make robust risk assessments about how they are using data and document that risk assessment. The core data subject rights, which I'm going to talk about in a moment, I'm getting signals that my time is up. I'm going to ignore that if you don't mind. So thank you for letting me know, but I'm going to keep going, as a former commissioner often will do. There are some core rights at the heart of GDPR with respect to end users that many companies needed to implement in order to get ready for GDPR. And as I was mentioning, these are some of the empowerment tools that are given to end users. It's the right to delete your data, to access your data, to port your data, to correct it, and to restrict the processing of it. Now, in order to provide those kinds of rights at scale, it required a company like Microsoft, which is not only dealing with our own data, the data that we have and that we need to provide data subject rights to, with respect to, but also we needed to enable all of our customers to be able to comply with GDPR. So we were in many ways kind of at the fulcrum and a very important player in the entire ecosystem of driving compliance with GDPR. With respect to our own data, what we have been able to do over the last 5 months or so since GDPR went online is we've been able to measure the extent to which individuals have accessed our tools for complying with GDPR. And what we discovered is that we've got so far about 8 million users around the globe who are interfacing with their data, who are actively looking at their data on our dashboard and potentially doing other things with it. One of the important lessons that we've learned from our data, from our dashboard, and being able to analyze the number of individuals who are accessing their data, is that actually in the United States we have a lot of interest in individuals controlling their data, seeing what it is, and exercising some of their rights. Indeed, there are more individuals in the United States who are accessing their data than there are in all of Europe, which is a truly remarkable statistic. So as of right now, again, about 8 million users worldwide are accessing their data, and out of those, it's about 2 million Europeans, and 2.9 or basically 3 million individuals in the United States. So what does this say? This says that individuals deeply care about their controlling their data. They want to have tools to be able to control their data. We have been able to provide that kind of information and those kinds of tools for them. And does this indicate that we think that there is space and appropriate activity with respect to a competitive play on privacy and providing these kinds of tools is a differentiator? Absolutely. For us, it absolutely is a differentiator. It kind of plays more, though, I think if you kind of poll the market and the kind of studies that we do internally, it isn't so much competition around privacy alone. It really, I think, privacy needs to be understood in a broader narrative around trust. And I think that companies are positioning themselves in terms of trusted players in the market. And so privacy, security, providing other tools, for instance, accessibility, these all are part of a broader trust narrative on which companies are absolutely competing. So why don't I stop there? But I'm sure we'll pick up the conversation more broadly. Sure.
Well, thank you to the FTC for inviting me to participate today in this discussion with my fellow former enforcers, Bill Baer and Julie, and thanks to Dan for giving that nice introduction. He mentioned my long government service, but now I'm enjoying some time off for good behavior. So I'm sure the other panelists before us have described the tools that can pull useful information from the flood of data that we are enjoying these days, and the tools that have great potential to make our lives better and provide significant benefits for consumers and businesses and government. But also, I'm sure they've discussed that these tools raise some privacy and other consumer protection concerns. Now, data and big data can also be important factors in competitive markets. although there are many facets of the interface between data and competition, in my limited time today, I want to touch briefly on just 2 points. The first one has been rarely discussed, and the second one has been discussed much more frequently. So the first point is about how competition can help address concerns that inaccurate big data analysis may harm some consumers. And my second point is about consumer data in a competition analysis. So turning to my first point, many observers, including the FTC in its 2016 report called Big Data, a Tool for Inclusion or Exclusion, so many have raised concerns about the effect of potential inaccuracies in big data analysis that may harm low-income or disadvantaged or vulnerable consumers. And indeed, although I agree that big data can provide many benefits, it's simply a tool. And like all tools, it has its strengths and its weaknesses, and it can be misleading and wrongly applied. For example, data sets, though large, may not represent the real world. And also, there is the multiple comparison problem, or comparisons problem, where researchers discover irrelevant statistical correlations that don't reveal anything useful about actual causation. Now, concerns about the effects of inaccurate consumer data are legitimate, and I've long supported frameworks like the Fair Credit Reporting Act that give consumers insight into data used to make important decisions about them and the chance to correct it. But regarding broader concerns about big data itself harming disadvantaged consumers, policymakers need to evaluate such concerns in the larger context of the market and the economic forces companies face. Businesses have strong incentives to seek accurate information about consumers, whatever tool they may use. Indeed, they use big data specifically to increase accuracy. And our competition expertise suggests that if one company draws incorrect conclusions about consumers and therefore misses opportunities to serve them, competitors with a better analysis will strive to fill the gap. Thus, big data analytics, combined with a competitive market, may help provide low-income and other disadvantaged consumers access to improved competitive offerings. Now, my second point is about the role of consumer data in an antitrust analysis. And this isn't a new concept for U.S. antitrust agencies. The agencies have analyzed consumer data in the context of numerous merger reviews, such as in the 2009 DOJ review of the Microsoft and Yahoo joint venture to combine portions of their online search and search advertising technology. And there are also court decisions resolving private antitrust actions that evaluated data as a commercial good, particularly consumer credit data. So these agency actions and court decisions demonstrate that acquisitions or conduct implicating consumer data can be examined under traditional antitrust laws. And also, as Julie has mentioned, companies are competing on the terms of privacy and trust. Now, I have concerns, however, with proposals to use antitrust to stop mergers or acquisitions by data-rich companies simply to address privacy concerns, not where the transaction or the behavior reduces privacy as a non-price attribute of competition, or where a merger would create undue power in the market for consumer data. Although concerns about the creation of large data sets with personal information aren't baseless, attempting to address these concerns by fitting them into an analytical rubric preoccupied with economic efficiency creates more issues than it solves. For example, it ignores the fact that consolidation of data across business platforms often creates significant efficiencies and gains in consumer welfare. Moreover, concerns about big data often revolve around the concept that compilations of even small and disconnected pieces of data, including data previously gathered and held by different parties, may be analyzed to reveal additional personal information about individuals, which then may be used for new purposes. And if the perceived privacy harm is the same, however, it would be strange to treat data combined through a merger differently from that compiled piecemeal by another type of entity, such as a large internet company, through its own connection and analysis. And furthermore, modifying the antitrust laws to encompass privacy concerns doesn't necessarily solve those privacy concerns, but instead creates incentives for firms to alter deal structures or enter alternative contractual relationships to take advantage of this asymmetric treatment under the law. And then finally, this approach risks reducing competition and innovation from new products that the combined data may enable, making all consumers worse off, even those who don't share the same privacy preferences or who are willing to trade some reduction in privacy for increased quality or new offerings. So in sum, competition law offers at best a convoluted and indirect approach to addressing privacy concerns in connection with big data. Now, although consumer data can be part of an antitrust analysis, the more direct route to protecting privacy lies in the consumer protection laws. So thank you, and I look forward to our discussion.
Thank you. So we've been having for a few days, well, and for years, discussions about the competition side, the consumer protection side, and I mean, to some extent, the nexus between them, as well as the divide between them. I think we'd like to start with something that's more competition focused, and this is a question for the entire panel, but maybe we'll start with Bill Baer. So for the three of you, during your tenure at the agencies, antitrust matters involving data cross your desks, whether it was a recommendation to close or to take an enforcement action, open an investigation. In your view, what were one or two of the most salient matters involving data while you were at your agency? What challenges did they pose? And what do you think about the resolution and what we might learn from the matter going forward?
Thanks, Dan. Let me talk about a couple of matters that came across my desk. Indeed, the first day on the job in early January of 2013, I was presented with a recommendation to challenge a consummated merger, the Bizarre Voice Power Review consummated merger. And while a lot of that challenge related to a merger to monopoly and the potential price effects from that, the fact that combining really the only two commercial enterprises that were going out to online retailers and selling a software product that would allow for product reviews to be compiled, basically centralized a whole lot of data, a whole lot of information in the hands of one firm in a market that looked like it was really combined to those third parties that were offering that service to retailers. And while, as I said, the merger monopoly pricing benefits that these companies unwisely discussed at great length in their business merger planning documents, evidence that we got and was successfully introduced in the Northern District of California in an effort successful to block that merger. We did also allege and express concern about whether or not the combination of these data sets would create significant insurmountable barriers to entry. We looked at the network effects associated with everybody basically going to one service. We looked at how that made for very, very high switching costs and how that would potentially enable Bizarre Voice to have unusual market power over price and stifle innovation and basically be in a position to prevent foreclose entry. Data also came up in a matter we didn't challenge. We looked very hard at Expedia Orbit's online travel service combination that occurred in about 2014, ultimately concluding that there was enough competition from the retail sites themselves, airlines, hotels, rental cars, that consumers actually had options, and that there was not going to be a unique set of data in the combined hands of the combined Expedia Orbits. And so we issued a closing statement saying we just did not see a competitive effect. I will say, if you go back over the years, looking at these issues has been something both agencies, and I've been at both of them, have done. You can go back to reservation systems back in the 80s. You can go back to the effort of Westlaw and Lexis to combine, a matter looked at by the DOJ some 20 years ago, and having unique ability to control information and access to information was both a price and a non-price effect worry, and the concerns tended to be the same, which is, will there be pricing benefits, but also will there be an inability of other firms to enter or expand into the market because there's unique control over information, which, as I understand it, was part of the DOJ concern in the Westlaw-Lexis merger some 20 years ago.
I can jump in. We have seen lots of mergers where data was part of the important collection of assets that the companies were trying to combine. We've had mergers involving things like real estate title plans or fire insurance maps. And we do a traditional, or the agency did, while I was there, did a traditional antitrust, I can't say we anymore, did a traditional antitrust analysis, much like Bill talked about. We look at, the agency would look at whether data can be an important asset, is it unique, is there some kind of barrier to entry that this combination will create such that, or market power in this. But often consumer data is easy to replicate. It can be gathered easily. The FTC's Consumer Protection Bureau has done some important studies on the prevalence of data brokers and the large amounts of information that are available in the market to purchase. So there really hasn't been a case that I can think of where consumer data was considered that the combination of that would create some sort of competitive issue. Now, when I was there and the commission looked at the purchase, Facebook's purchase of WhatsApp, commentators did raise privacy concerns, saying, well, the WhatsApp data was collected under a certain set of promises, and if Facebook combines it with its data, then those promises may be violated. But I saw that as a privacy issue, and what the commission did there was the head of the Bureau of Consumer Protection at the time issued a letter reminding the company that it needed to adhere to those promises to those consumers. And if they didn't, then I would see that as a fairly straightforward consumer protection issue. Now, one of the other challenges, I think, about looking at data in antitrust review is where we have found problems. The remedy has been to share the data more freely, to make a copy of the data set or the title plant information, which is how you do title searches for real estate. And so importing a privacy analysis, privacy concerns into this analysis, again, is a very awkward fit, because I don't think the people who are concerned about privacy say, well, what a great outcome, that data will be shared more freely, more widely.
So I would, rather than talking about actual cases, just to distill out a little bit of what we heard from Bill and Maureen, I would say that from a regulator's perspective, there's two challenges to how you deal with whether it's mergers or other potentially anti-competitive practices dealing with data. One is to determine whether the data is competitively significant. And as we've heard, there's a lot of nuance to that issue. The first question I think that would need to be answered by the investigators and the regulators would be, do the parties at issue actually own or control the data, or are they merely processing it for others? That seems to me to be a major gating issue, right? If you don't actually own or control the data, but are merely processing it for others, and others are the ones who own and control it, then I think you have much less of a competitive problem, potentially. The second issue to determine whether data is competitively significant is whether it is a critical input, or assuming that you do own it, unless you're actually marketing that data. And there are two merging parties that are marketing the data, and that there will be some increased in concentration in that market for that particular type of data. It's pretty, in terms of whether data is a critical input, it could happen, but I don't think we've seen that much of it at the FTC or elsewhere, and that's because even if a party kind of has its own data and its own data set, the real issue is what are they doing with that as an input in the downstream market. And if there's competition in that downstream market, even if other players don't have that critical input, but they're able to compete, then you really have to think a little bit more broadly about whether indeed you have a competitively significant data set. And then, of course, there's the issue of reasonable substitutes. So all of those are questions that go into just the first challenge of determining whether or not the data is competitively significant. Maureen pointed out that that's just sort of the beginning. Once you do have competitively significant data that you want to address in the context of a case, then the question becomes, well, what is the remedy? And we are hearing a lot more about calls for sharing data sets. First, of course, you need to get over that first hurdle of do you have competitively significant data. And in the world of multi-homing, that's a hard thing to say, multi-homing, and consumers placing their data in many, many different places, and also in a world where what is really significant is not one data set, but the heterogeneity of data that is used for AI, and hopefully we'll get to that in a little bit. It is really hard to say that in the area of consumer data, you are going to have one single data set that is competitively significant. But once you get to this issue of needing to find a remedy, sharing data, I think what I would urge regulators to think about is, if you are automatically going to kind of go to that place, well, first of all, are you breaking some of the sort of normal traditional U.S. rules about having some sort of legal basis to impose compulsory licensing? Do you have a refusal to deal? Are you in that world? And then it's sort of at a bigger picture, sort of policy level. If data gets shared pretty easily, you do have the concern that Maureen raised about potential privacy issues, but also more focused on the competitive effect. What does it mean if data gets shared pretty easily in terms of innovation by other parties? I mean, don't we want to incentivize parties to really go out and compete with respect to some of these issues and with respect to driving innovations so that data becomes more competitively significant kind of across the ecosystem? Easy sharing, I think, actually would maybe inhibit that kind of innovation. So this issue of the remedies, that assuming you're in a place where you do have competitively significant data and you do have a problem that needs to be addressed, I think the issue of remedies is actually the hardest of the issues, as opposed to just sort of getting through that process of, do we have a competitive problem to begin with?
Thanks, Julie. And I think issues involving innovation and how to best support that are certainly things that we'll keep discussing throughout this panel. One other question specific to antitrust and big data. We're on the third day of our hearing on the intersection of big data, privacy, and competition. There's been a lot of discussion and leading up to this point, ink spilt about this topic, and we've heard about essential facilities, refusals to deal, price discrimination, and my question is simply, are the concerns about big data in antitrust warranted? And then a secondary question is, can a merger involving consumer data, if not a product or service for sale by horizontal competitors, but rather an input used by both merging parties, give rise to an antitrust violation, and if so, under what circumstances? Maureen, would you like to start with that?
Sure. So let me jump in first about the issue of essential facilities argument and refusals to deal. I don't see why for big data that would be any different than the concerns and the analysis that we have in analysis involving other types of property. Like we've hashed this out quite a bit in intellectual property when there are concerns about forced sharing. I mean, intellectual property is really just a kind of data, right? What's the formula? What's the, what's the code? Something like that. So I would definitely have concerns about saying, well, just because it's big data, we're going to make it more likely to find an essential facilities argument, or more likely to say there's a refusal to deal that violates the antitrust laws. I mean, not that it's impossible. I mean, but I think it should be. Well, I'm not a fan of the essential facilities doctrine for the reasons that Julie mentioned. I think it suppresses investment and affects dynamic competition down the road. And then in the merger context, I think it is theoretically possible that you could say consumer level data is such a key asset that the combination of these two data sets could lead to market power in some way. But I think there's a lot of reasons why it seems less likely in this area than in other areas where we found those combination of assets to be problematic. It would have to the things that Julie mentioned, that someone else couldn't replicate it, that someone else couldn't. There couldn't be a reasonable substitute for that data. So I think that while it's theoretically possible, I would be a little, it'd be interesting to see the first case that brings that.
Let me pick up on that and focus, Katie, on the question you raised about the input market. And really it is, again, traditional antitrust analysis. If a merger is going to allow a firm to, in some ways, create market power over a critical input at the next level of competition, that's a legitimate antitrust question, whether it involves big data or not. I mean, if you look back to a case I was involved in 20 years ago, the Mylan case at the FTC, that was actually single firm behavior, where a generic firm basically was able to create market power in the generic market for a number of generic products by basically tying up the few suppliers of the key active ingredient for a series of generics. And if you had that situation involving data, I think you would analyze it the same way the Commission did in the Mylan case. For me, switching over to a concluding point Julie made, an interesting issue is the point Julie raised about remedy. If you assume that you have in a transaction, a merger or an acquisition, the potential for there to be control over whether you call it an input or some sort of data that creates market power, how do you remedy it? And if the answer is not a license to somebody to give them the same opportunity to compete, and I understand the reasons why Julie said that can be problematic, what is the answer? Is it simply seeking an injunction against the transaction?
Right. I mean, it may be. It may be. But I mean, so I'm actually a big believer that the antitrust tools that we have are robust enough to deal with these issues, but I do think it's important for the regulators to actually understand the issue at hand. So one of the so as you may know, or keen observers of the FTC may know, I actually even though I was a majority non-chair commissioner, I did dissent. And when I dissented about 10, 15 times. Each one was in an antitrust matter. not a consumer protection matter. And each of my dissents was because I felt that the agency wasn't taking a robust enough position. So my view has long been that the antitrust laws are actually, we have some really good tools at our fingertips to deal with issues, including, I think, issues around data. My concern has long been that regulators, when I was a regulator, my concern was, and my concern still is, that regulators really are not thinking creatively and using the tools that they have when they can be used. So I do think that, as you said, the remedy might simply be that, look, if the problem would be that sharing data raises the types of concerns that I talked about, maybe you do look at simply stopping the merger or doing some other creative things. I think what I wanted to address, though, was sort of the predicate of your question, which is that we have big data. And I think it's important to think about, like, what is big data? So on some level, as Maureen said, the FTC has written a couple of reports about this. And it used to be that we talked about the 3 V's, volume, velocity, and variety. Thank you. I think I would actually now, now that I'm seeing things kind of on the ground and from the side of a tech company, I would say that yes, there's volume. Yes, there is velocity. Variety is super important too. I would say that we would probably need to add in analysis. I can't think of a V word for that, but algorithms are an incredibly important aspect of what is happening with respect to big data and how the incredible increase in computing power that we now have, along with data science, marrying that up, really makes big data very significant when it comes to the issue of analysis. But what is significant about big data is not just its bigness. And so I think it's a misnomer to simply think about volume. So maybe I would subtract that V from what is competitively significant. Instead, I think it's really important to be thinking about the actual nature of the data, the sensitivity, if we're thinking about privacy, of the data, and its relevance to any particular algorithm or analysis at hand. As you think about, and you will be, as regulators, thinking about the competitive significance of big data in an AI world, I think you need to be thinking more about heterogeneity than about bigness. In order to really have a robust AI technology, you need to have a variety of inputs. So that, to me, volume is important, but what I'm hearing from data scientists, what I'm hearing from technologists is that computing power, analysis, and variety, heterogeneity, are really what is key. And then also, of course, to the extent that you have specialized issues at hand. So to your point about, thinking about Mylan or thinking about medical data, thinking about roofing analysis, as we did back when Maureen and I were both on the commission, that's highly specialized data, and often that is very difficult to replicate. So I think as regulators move forward in an AI world where AI is going to provide so many benefits to society, but also needs to be dealt with appropriately and responsibly, I think it's going to be important to be thinking about big data with a lot more subtlety than simply waving your hands and saying, bigness is bad and we need to worry about all large data sets.
So here's a question, follows up maybe some on Julie's slides, but also on both policy discussions and empirical work that were presented yesterday having to do with GDPR. And just to frame the question, I want to at least distinguish between having real grounds for competition concerns on the one hand from having done a full-blown analysis on the other. But so both GDPR and the new California Consumer Privacy Act of 2018, which will go into effect in 2020, assuming things go as charted, extend certain protections to consumers by imposing new responsibilities and, of course, costs on firms. Some smaller firms have said the compliance costs under GDPR are particularly burdensome for them. There's some preliminary evidence of GDPR's impact on tech investment and some ad hoc reports of U.S. firms declining to do business in Europe. And of course, I mean, there's an interesting dynamic here when we're talking about trade-off. We have both theoretical and empirical work suggesting, I mean, in some ways, even large firms doing their darndest to be good actors can support standards policies that are very hard for smaller firms, innovators, entrants to meet. And so here, reflecting on provisions of GDPR, which does make some, but maybe not other small firm, large firm distinctions, the California Act, do compliance costs at some point or come to some point raise special concerns for innovation and competition? Do these types of laws place, at least under some circumstances, privacy rights or interests in tension with competition or innovation?
Can I jump in on this
Yeah.
one? Okay. So I'll kick this off. This is actually a really interesting, I believe, ultimately philosophical question about the role of any regulation and its competitive impact. I have heard a lot of the discussion around GDPR as potentially imposing competitive barriers for small firms. I think we need to take a step back and really think about regulation in any space and what it could do to small players or players that aren't ready to comply. Think about the Food and Drug Act. Think about auto safety laws, Sarbanes-Oxley, even if I dare say COPPA. All of these regimes are developed because whether it's Congress or the European Parliament or other policymakers decide that there needs to be some boundaries placed around competition. That's what regulation is. I mean, you're basically saying, you're no longer free to do anything you want in this space. You're going to have to comply with some rules. And when those rules are put into place, there's always disruption. I mean, I'll focus on, we could do the tobacco law, we could do food and drug. The Food and Drug Act, probably it was first enacted over 100 years ago. Suddenly selling snake oil wasn't okay. Is that disruptive? Yeah, it's disruptive. But that doesn't, does it affect competition? Sure. For snake oil purveyors, it affected competition. But what it means is that society has said there are certain boundaries we're going to place, and these policies that we're now putting in place are going to need to take a precedent over free rein in that particular space in the economy. Does GDPR do the same thing? Arguably, yes. It does create boundaries around the way in which data can be used. It creates rules and a system for dealing with data and dealing with personal data. Does this have a disruptive effect? Yes. Will the effect be temporary or permanent? I think that's going to be a big question. So some of the data that was cited yesterday, 4 months worth of one particular type of data, I would really want to see how that compares to what happened when other regulatory regimes were put in place in terms of investment. But the real question is what's going to happen in the long term and whether the policy decision to impose those boundaries made sense over the long haul. And I would say that with respect to GDPR, what you're going to see is there will be a huge amount of pro-competitive impact from laws like GDPR. I don't want to talk about California yet because I think we're still waiting to see what that will actually look like. It doesn't go into effect until 2020, I believe, and there may be some further amendments to it. But from my perch, we've seen a lot of competition with respect to GDPR, particularly in the cloud space. That is, you've got cloud providers, Microsoft being one, that is we're informing our customers, we will help you comply. We have a comparative advantage, just as we do in security. We have the technologists. We have the ability to figure out how to keep your data secure. We have the ability to create tools for you to comply with GDPR. You come to the cloud, and what will happen is you are free as a medium, small, or even very, very large company, you're free to focus on your business. And you don't have to focus on building an infrastructure that we have built for you. And by the way, if you come to a place like Microsoft, and we're not unique in this, I mean, there are other cloud providers that are doing this too. If you come to us, you'll be able to tell your consumers, your end users, or your business customers that you're using a very trusted cloud provider and that they can trust where their data is going. So there's huge amounts of competition in this space. So I would say that, I could go on, but I want to let my fellow panelists address this issue. I would say the real issue is not, is GDPR anti-competitive because it's hard for small players to comply. The real issue is there competition happening because of a regulatory regime being put in place? And the answer to that is yes. Will small players have difficulty? The truth is, from our perspective, the smallest of the players are actually the most agile, and the new startups are actually more agile. They're able to build to GDPR. The real difficulty that we're seeing with respect to some of our customers is medium-size, older firms with legacy data systems. They're the ones that are having the most difficulty. So it's really, again, not an issue of smallness versus bigness. It's an issue of agility or not agility, newness, not newness. And then when you're looking at the competitive landscape, you really need to look at those entities that are providing these kinds of services and using kind of the Adam Smith philosophy of, we've got a comparative advantage. You go do your business, we'll do our business, and we'll help you do your business better.
Yeah, I agree with, as I often do with most of what Julie had to say, and to the extent I elaborate, it's more of an elaboration than a difference. We are talking about a competitive market when we talk about privacy and data security, big data, where the market may not work to reward the people who do the best job of providing data security, or where the incentives may be to focus on sales and less on protecting your individual privacy rights. And so in that context, as a political decision, there may well be, as Julie says, a need for governments to intervene, not as antitrust enforcers, but as regulators. We don't like to do that. We prefer the market correct problems, but there are situations. The environment is a good example, as is food, drug, and cosmetic safety. And so we intervene. We know that there is some cost to intervention, but again, as Julie said, focusing, channeling through the regulatory process competitive incentives to basically make privacy more of a concern is a legitimate goal of government. It kind of trumps the presumption in favor of free markets if the harm or risk of harm is big enough. But I think part of the reason you go there in this space is, even though Microsoft may be extraordinary at providing protection for privacy and for security and is able to market that, it's very hard for the average consumer out there to know whether it is marketing material. It's a privacy snake oil. Sure. I mean, it's right, and that, so having GDPR, other kind of regulatory things that set a floor in terms of what you must do, channel incentives, is actually a way to basically allow us to make decisions about a provider we're going to use, knowing there's some kind of privacy safety net out there. Without that, without that, I think we're left out in the wilderness.
So I agree with both Bill and Julie that any regulation is likely to have a competitive impact, right? It's one of the reasons why the FTC has had this long history of robust competition advocacy, where the agency has commented on regulations and their likely impact on competition. And it's across the board. It's not just privacy, it's health, dental hygienist, nurse practitioner, the list goes on. And so I don't think the question is, should there be regulation or no regulation? I think there's a fairly wide agreement that privacy is an important value. It should be protected to a certain extent. I think the question for competition and innovation down the road is, are you protecting it at the right level such that in the long run consumers are going to be better off? Because what's not necessarily capable of easy measurement is the innovation that's not happening because the use of data is being restricted too much. And I think that's a harder question, but often people raise the question about whether the European regulators are picking on American companies, right? The big American tech companies. And they say, no, we're not. These just happen to be the companies that are in this space doing this. And I like to back up from that and ask the different question of, why is it that the American companies have been the ones who have really innovated in this space and created these new products and created these new markets and satisfied, demands for consumers and led to a whole lot of benefit in consumer innovation? Now, that doesn't mean, we should have no regulation, but I think we need to think about it at that level also. Are we going to make innovation by using data too difficult, such that consumers are going to miss out on some benefits down the road that could actually be well worth the exchange in, how much their privacy and data is protected?
So we have a question from the floor, this one on the issue of potential remedies or solutions for some of the big data challenges. Could a broad data portability requirement offset some of the call or need for compulsory data sharing as a remedy? And my annotation is, even if not an antitrust violation, would such a requirement increase competition by reducing switching costs?
So I'll jump in on that. GDPR does have a portability requirement in it. It's interesting when you sit back and think about that requirement to provide users with the ability to port their data. It is an empowerment tool. It is focusing on privacy as control, as opposed to the right to be left alone. So it is part of a much more modern concept of privacy. But also from, I think, a U.S. regulator's perspective, it looked a lot more like an antitrust or competition element to GDPR. I actually think that the portability requirement could have a lot of pro-competitive effects. Portability needs to be coupled, though, with interoperability, because it's one thing to give a user their data. It's another thing for them to be able to actually upload it and use it in a functional way on another platform. So one of the things that is happening right now is that a couple of the very largest players, Microsoft being one, Google being another, we are working on an open source project to have sort of some uniform standards by which data can be ported so that it will truly be interoperable. So we're sort of recognizing the call that the Europeans have made that portability should help augment competition going forward. But the only way it's really going to work is if you have truly interoperable portability. And so we're working on that through an open source project. I do think it has promise. It's going to take a little bit of time. If you go back to the dashboard that we showed you and all that interaction, 8 million people looking at their data, correcting their data and whatnot, we're not seeing a lot of portability requests because, where would it go?
The denominator?
Of what?
8 million over what?
Millions and millions and millions. But having said that, it's a very significant number. And I think what's especially significant is the relative proportionality or the relativity of that interest in control. And this goes to something that I was going to comment on Maureen's point about being careful when we develop laws in the United States about privacy and what the effect might be on innovation. I absolutely agree that that's something we need to take into consideration, but we also need to see that relative to the rest of the world, U.S. Citizens seem to care an awful lot about privacy, and that we need to sort of debunk this notion that privacy is of lesser importance than some of these other policy matters like innovation. It's very important.
Just one quick add to that, if you, and relating to the degree of difficulty involved in making portability work, you think about the pro-competitive benefits of the FCC rule some years ago that allows you to take your cell phone number from one carrier to another. That's like wading into the baby pool at a public swimming pool as compared to the 10-meter, 3.0 degree of difficulty dive in terms of finding a way to make sure that even though you have portability, that you have functionality, interoperability with it. So it's important, it's possible, but it really requires a whole lot more than in a simpler situation, a simpler world.
And my only question there is, will consumers really use it, right? Will it achieve the goal that the drafters, the people who came up with this requirement in GDPR want it to achieve?
And I think that's a good question.
And if it doesn't, then where do they go from there?
I think it's a great question, but until we get to a place where it's functional or interoperable, we won't know. So that's why we need, industry is really taking the lead here. We're working with the regulators in Europe, and they're very pleased that we're moving forward with this open source project to help that, to see the reality, to their dream of being able to truly port data. And I think your analogy to the cell phone portability, the cell phone number portability is a great one.
You can use it.
I have.
Can I just maybe follow up here a little bit? So it seems there's a consensus on the panel, not controversial, I think, in the larger world, consumers have privacy interests that might be more or less well served by competition in one domain or another. There's a consensus that regulations can serve varied ends and will have some competitive impact. It doesn't mean that they're a net loss for consumers. There is a question what they're supposed to do and achieve, right? Are they responding to some sort of significant and demonstrable market failure? Is it likely to be durable? Can the harm be efficiently ameliorated? So, in one sense, of course, we have regulation here. In another sense, one model or another. The snake oil example seems to me to be instructive, and maybe, we have 2 out of 3 former FTC commissioners here. FTC has done a lot of work on snake oil, nutrition marketing, dovetailing with FDA, calibrating regulations and certain sorts of assurances and floor with actual risks. So how do we get at sort of not the question whether they're legitimate consumer concerns that something, whether it's GDPR or FTC enforcement, might respond to, right? But the magnitude and species of consumer harm we're addressing, the question whether the tool is well tailored to meet it. How do we assess not the question whether there should be some floor or not, but where the heck it should be on the competition side or the consumer protection side?
So let me offer just by analogy, some of the things that have been really useful, you mentioned in the FDA context. So the FDA used to prohibit health claims about foods, essentially. And a cereal manufacturer felt that the science showing the benefits of having more fiber in your diet were so strong that they decided to push the envelope and just go ahead with the advertising in that. And the interesting thing that happened from that, and there's good FTC economic studies about this, is it led to this great increase in consumers eating fiber in their diets because the competitive dynamic that happened of a company saying, hey, you know, eat our cereal, it's got fiber in it, and consumers read their cereal boxes a lot more than they read any government advice about diet. And then other companies came in and then they also introduced these products. So we need to be careful. And that showed actually that advertising restriction was actually making consumers worse off, was suppressing very useful information, and the products weren't appearing in the market because the companies couldn't advertise them. So I think that looking at some kind of natural experiment like that through an economic study, if possible, I don't know whether it would be looking at, you know, where innovation has happened in products that use data, you know, in the U.S. versus other areas, you know, trying to get at that, like how do we figure out what the right level is? Because it's very difficult to measure in the abstract what doesn't happen. You have to be able to compare it against something else. So if we, you know, I don't know if it's possible to use an economic study that looked at, you know, where were data intensive businesses developed in what part of the world, and then what their privacy regimes looked like. I mean, the hard part is also there's a lot of different factors that go into business success, but just looking at other examples from other types of regulation, we have been able to do that kind of experiment.
I just want to throw one concept out here for us in the U.S. It's a somewhat foreign notion, but many people around the world don't think of privacy as simply an attribute of a product, but think of it as a fundamental right. And I think to the extent that we have global players or companies that want to exist on a global market, you have to take into account the fact that the rest of the many regions around the world don't look at privacy and data use in the same way that we have traditionally looked at it. And frankly, I think if you take a close look at the California law and what is happening in other states, there is a paradigm shift in the way that privacy is being thought of. And I'm not disagreeing with the question. I think it's an important question to ask, what is the harm? But when you're thinking about harm, I think we're going to have to start looking at the harm to rights in addition to the harm to sort of what we more traditionally think of for individuals, because that is the way that privacy and data use is shifting around the globe.
I mean, I think that's right, and I think, you know, it is often articulated as a fundamental right outside the U.S. In the U.S., you know, it's a constitutional right. It's very important.
Vis-a-vis the government. Vis-a-vis the government. Absolutely.
Right, but also, I mean, different rights need to be balanced. So one of the examples of taking these things too far that I heard, which I found so sad, was that in Japan, after they had the tsunamis and the nuclear incident, some local groups, and you know there were so many people in need, said, could we get a list of people who are blind or disabled, so that because they may be stranded and you know they can't kind of get out on their own? And the answer they got was, well, no, because that would be a privacy violation. And I think you're right to receive life-saving services from the government would need to be balanced against your privacy. So I don't think that saying it's a fundamental right is the end of the discussion. I think it's important to realize that even fundamental rights can be in conflict with each other and need to be balanced.
So I agree with that. I was pointing it out because I think it's important to understand that if companies want to be competitive on the global stage, they need to either embrace this notion and understand what it means or not. But if you fail to embrace the notion that in many other very important markets, privacy is a fundamental right, then you won't be able to effectively compete in those markets. In terms of problematic issues that arise in the data space, I am aware of that circumstance that you're describing, and I think that was a tragedy. And yet we can find examples on the other end of the spectrum where the failure to have broad-based privacy laws in the United States may have led to other major problems. We could look at the Cambridge Analytica scenario and the extent to which data was, for a time, very freely shared with third parties without consumers having control or understanding about it. Had there been, it's a question I'm asking, I'm not going to say that GDPR would have stopped that, but had there been some kind of baseline privacy legislation in the United States, the question is whether that type of activity would have been less likely to have happened or potentially less severe. And I think that's an important question to ask. So I agree with you, we need to balance rights for sure. But we also need to understand where the rest of the world is going if we actually want to have companies that are competitive around the rest of the world.
I think that's a great point, and even if companies failed with a U.S. regimen, failed to adhere to it, the fact of FTC enforcement action and significant penalties, you'd prefer it to be a deterrent at the front end, but at the back end, other companies will learn if sanctions are imposed.
So this is in part a question from the audience, but it touches on issues that both Maureen and Julie have raised in terms of company analytics and the role for competition to provide a venue by which good analytics rise to the forefront. So two-part question, how can society operationalize Julie's point about assessing the type of analysis that firms can do with their data? And then also for Maureen, what's the mechanism by which competition could produce accurate consumer-enhancing data analytics? Is there a role for enforcement or advocacy? And I know we have just a couple minutes.
Yeah, if everyone can just take a minute, and then we're done.
Okay. I'll go first on the part addressed to me. Has anybody read the book Moneyball? Right? Moneyball. So Moneyball is all about using better analytics, using data more accurately to come to a better outcome, right? The Oakland A's were terrible till, they hired, a good data cruncher who had this idea that, the way players were being chosen wasn't, the data wasn't being used appropriately, other types of data. So I do think that, the same kind of thing can happen in, a whole host of products. If you have better analytics, you can target better, opportunities or make your product better. So I think that is a common kind of thing. But I would recommend Moneyball to anyone who wants to know one particular application.
To the first part of the question about how does one operationalize this issue, I think it's really important. I want to talk about operationalizing it from the regulator's perspective. I always used to say that regulators were about 5 or 6 years behind where technology was. That has definitely accelerated. I think having chief technology officers and having the technology folks at the FTC and at other regulators has definitely helped kind of shrink that gap. But even a 6-month gap is enormous these days because technology is moving so quickly. I would say that if you really want to operationalize an analysis of how data is used in these sort of more complex AI systems, the FTC, which it has been doing through these hearings, really needs to get a deep understanding of what's going on today and what will likely be going on in 6 months and a year at some of the firms that are really thinking about this deeply.
Good. Thanks. Well, in the 7 seconds remaining, I think that all I can really do is thank our panel for your time and really the substance of your excellent contributions, and thank everyone watching here and over the webcast. Thank you very much, and we'll see you at the next hearing.